Good evening, members, ladies and gentlemen, the audience. The clock has struck, so we will start. So first of all, I'd just like to say I've been advised there are no fire drills planned for tonight, but if alarm does sound, Mrs. Snook, who's sitting on my right here, will ascertain the situation and provide further instructions. I would also remind you that this meeting will be broadcast live and recorded for playback on the Maidstone Borough Council website. But will anybody else be recording or filming proceedings? I'm only asking you this so that people know this will be happening. No? Okay, thank you very much. I'd also ask the members who are using mobile phones or tablets are asked, please ensure that these are on silent and are only being used with regard to the business on the agenda this evening, which reminds me I've got to put mine on silence as well, because I just forgot. Thank you. Okay. Apologies for absence. I've had apologies from Councillor Munford, Round and Mrs. Stockholm. Okay. Notification of substitute members.
Councillor Burton, subbing for Councillor Round.
Thank you. Thank you.
And Councillor Mrs. Gooch for Councillor Munford.
Thank you. Thank you very much. Notification of visiting members. Is that for which agenda item are you? Okay, thank you. Yep. Thank you. I'll also note Councillor de Wigadeen is on his way as a visiting member, but I think he may be stuck in traffic. But please forgive him if he's slightly late. Okay, we will note that as well. Agenda item 4, items withdrawn from the agenda. Mr. Bailey, would you like to comment?
Yes, Chair. I've requested that item 15, 47 Freeman Way, be withdrawn from the agenda tonight. Obviously, members will need to vote on that. My reasons for this is because there are some inaccuracies within the report that I need further investigation. I've tried to ascertain the building regs approval plans, and unfortunately it's done by an independent building surveyor. So on this basis, I need to investigate those plans in more detail before I'm satisfied that the issues relating to the dormer window are actually permitted, notwithstanding what's said in the officer's report. So there is a further investigation on that basis. And on that basis, I would request that it's withdrawn from the agenda, and I'll bring it back once those investigations have concluded. So I apologise for that, members, but I think it's essential that you have up-to-date, correct information.
Thank you, Mr. Bailey. Are we all agreed for that to be withdrawn? Okay. Thank you very much for that. Welcome, Councillor Powell.
Yeah, I do apologise, Mr. Chair.
That's okay.
Yes.
Under item 5, the adjournment date, hopefully we won't need it, but it's the 19th of January. I realise we do have a big agenda, but hopefully we can move reasonably fast through it. Agenda item 6, we do have a number of urgent update reports. Some have been previously seen. There are some that are unseen till today. Are we all happy with those? I will remind everybody when we come to each agenda item. I've noted them, the ones that apply to each agenda item. Okay, good. Disclosures by members and officers. Councillor Harwood.
Thank you, Chairman. I need to disclose in relation to item 18, Vinters Park Crematorium, Bearsted Road, that I am a member of Boxley Parish Council, but I took no part in any discussion at the parish, so therefore intend to speak and vote. Thank you.
That's fine, Councillor Harwood. Thank you. Anybody else? No? Okay. Lobbying. I'm tempted to say I'll do this as I go along, but I often forget. So I'm going to ask you quickly who's been lobbied on various agenda items. I'm going to do it now so I don't get told off afterwards. Agenda item 13? I think we've all been lobbied on that, I suspect. And 14 as well, I suspect the hands will go up for that one. 15? 16? Are you right? Oh, I'm Terry. Oh, yeah, I'm jumping the gun here. I'm told we have to have the names. Well, it's everybody for 13 and 14, I think. Okay. And 15? Okay, so it's 1, 2, 3, 4. Councillor Powell, Councillor Broughton, Councillor Cox, and I think Councillor Gooch or Councillor English. Okay.
Gooch, no?
That's it?
Gooch, no.
Gooch. No, not Gooch. No. Yeah, English. Okay. Agenda 16. That's Councillor Harwood, Councillor Broughton, Councillor Hemsley. And you actually me as well. I just suddenly realised, so you put me down. Just to get the name. Sorry about this. It's a big agenda, but we need to get it right. Yeah. Agenda item 17.
Sorry, Chairman, I'm not
Yes.
sure, but I think I have. I just can't remember. Sorry.
Oh, when in doubt.
When in doubt, put your hand up.
And Councillor English, okay. All right, Councillor A. Sorry, no.
The Councillor Perth, 17. Sorry,
Councillor Powell on 17. Not on 17, no, I don't think so. Okay, all right, so we've done 18. 18? Agenda 18? 2. Oh, it's getting easier. Yeah. Right. Gosh, so many. Okay. 19, agenda item. That's an NBC one, isn't it? So we could argue. I think we're involved with that. Agenda item 20, Warm Lake Farmhouse. Well, I've been looked on that. I think everybody has almost. It's everybody.
Who hasn't?
Councillor Clark, I think.
Councillor Clark.
Yeah. All right. And agenda item 21 is one of ours again, so I think we can. Agenda item 22, which is Coxheath, yes. Agenda item 22.
22. Okay. All right.
That's pretty well everybody.
So who hasn't?
Oh,
Who
my,
hasn't?
Councillor Hemsley, I think. Oh, you have.
So,
It's everybody.
except
It's-
Councillor Clark?
Okay. Yeah, he had his hand out before, yeah. All right. And then 23 is one of ours, so we won't worry about that. All right. Sorry about that. That took longer than I thought, but it is quite a long agenda. Right, okay. All right. Minutes of the meeting. No, sorry. Agenda item 9. Any items taken in private. There aren't any yellow pages, so I think we're all happy. We go ahead. 10. Minutes of the meeting held on the 8th of December. Has everybody seen them? Are they agreed? Agreed. Okay. Agenda item 11. Presentation of any petitions. I don't think there are any, so that one can go through. Deferred item 12, or agenda item 12, that's a deferred item. Do you want to speak on that?
Yes, Chair. Unfortunately, the officer who is the case officer, this has now left the council. It is with the principal planning officer, and he's under clear instructions to progress it, bring it to planning committee, and I will be seeking to make sure that occurs. So apologies that it's delayed again. It will be coming forward soon.
Thank you, James. Just very, very briefly, I think, James, you want to make a statement on the progress on the inspector's interim report. But it's very brief, so...
Yeah, I'm not going to go into detail. Obviously, members will be aware that before Christmas on the 22nd December, the Robert Mellor submitted his interim findings. They have been emailed around to members and they are on the Council's public website. I don't intend to go into those details, but needless to say, in terms of the Council is working with the interim findings and producing documents to ensure that what we are doing is akin to what the inspectors are expecting us to do. They are going to the inspector, so we'll soon receive whether what we think he's saying in the report is what we're actually saying. And as soon as that's confirmed, there will be, that will be more formalised. You'll see differences coming in committee reports. I think all I will add is that the inspector in effect endorses the 5-year supply position, doesn't raise a particular issue with it, as you're all aware, reduces the AON figure. They're not full findings, they're interim findings, and they're an aid to help the Council move forward. But obviously it is a material consideration in terms of the application, and you'll be having further updates as we move forward. I don't wish to say anything more than that. The reasons why the reports don't go into the details on the interim finding is for that particular reason. We need to have certainty that Mr Mellor is satisfied with the approach we're taking and moving forward. Thank you, Chair.
I don't intend to get into debate on this because I think it's being discussed in other fora as well. But I thank you for that because it sets the scene very, very well. Okay, I think we can go on to agenda item 13. And the first item on the agenda, actually, for us to review and look at is land at Barty Farm, Roundwell, Bearsted, Kent, and it's reference 14//506738. Do you want to go through?
Yeah, thank you, Chair. I'm just going to briefly, before the case officer introduces this item, just set out to members that obviously the report is not going to go into the full details of the application previously considered. That application, there is a resolution to approve that application subject to 106, which was taken by members on the 28th of April Committee 2016. The purpose of this report is to update changes on material considerations, principally relating to 5-year supply, the minerals, Kent Minerals and Waste Local Plan, and also the issues and the changes to the listed wall and the implications that arises. So what members will need to bear in mind is that there was a resolution to approve, identifying that there was a degree of harm arising from that development. That degree of harm was considered less than significant by members, and the needs of the development outweighed that harm. So members did resolve to approve that application, and this application moving forward updates on those material changes. Obviously then you'll then go on to the listed building consent, which will consider the works to the listed building, and the case officer will explain those in further detail as well. So there'll be 2 separate decisions on those items tonight, and I'll hand over to the case officer to address the details of the report. Thank you, Mr Chairman.
Good evening. The material changes that fall now to be considered on this outline planning application are firstly, as James alluded to, the change in position with regard to the 5-year housing land supply. Obviously, Barty Farm is actually a proposed allocated site in the emerging local plan. It's not been raised as a specific concern in the inspector's interim report on the examination in public. And as mentioned at the Planning Committee last April, the Council at that point couldn't demonstrate a 5-year supply. Obviously now with the submission we are saying that we can actually demonstrate the 5-year supply. So for those reasons it was felt appropriate. It's a material change. We are now bringing back the application to committee. And Barty Farm, the allocation contributes to that 5-year supply. The second material change on this application is that KCC have now actually adopted the Kent Minerals and Waste Local Plan 2016. The applicants have submitted a mineral resource assessment report with the application, which has been considered. This site hasn't actually been prioritised as a preferred or reserve site. And considering the conclusions of that report, it's not felt that it affects the previous decision reached by members of this council. The third material change is that relating to the actual design of the scheme and the relocation of the listed wall. As you'll be aware, in order to facilitate an access into the development site, the curtilage wall of Barty House needs to be basically demolished and realigned. This photograph here shows you the picture of the actual main wall in question, and this is the access into the development site. So this is the wall which was previously considered by members in April last year. So the proposal, as previous, is to carefully demolish and reconstruct the wall. It's proposed to include the reuse of as many of the existing bricks and materials as actually possible. Now, the amendments that have taken place don't actually propose to change the previously considered alignment of the wall. So if I just point out on this plan, this was the actual plan which last time was before members in April, which shows the realignment of the wall. So this is the facade of Barty House, this is the realigned location, and this is the existing location of the wall. Now, the plan which previously was subject to the resolution when members considered it was to rebuild the wall at approximately the same height as existing, which varies because of the levels, but approximately 1.9 metres in height. And again, as I said, the actual siting will be the same. It varies between 2.5 and 3.5 metres set in, depending at what point you take the measurements. Members did consider the impact of the listed building when they considered the outline application, and in April accepted the professional views of the Maidstone Conservation Officer that the scheme would cause less than substantial harm. The public benefit test in paragraph 134 of the MPPF was then applied, and the impact at the time was deemed acceptable, as was the loss of the curtilage and the impact on the setting of Barty House. So the revised schemes, I've said, it remains a proposal to demolish and relocate the wall along the same line. Sorry for reiterating it, I just want to make it absolutely clear. However, where the scheme now differs is this was the previous proposal that members considered, and I will now move to the current revised proposal. So you'll see the realignment is on the same line. However, the introduction now is proposed of some access steps midway along where the wall would be rebuilt. These access steps would come off the back of the public footpath, which would actually be now implemented as part of the accessway. In addition to that, the actual rebuild of the wall will be at a lesser height than what was previously proposed. So the actual height now will be approximately 1 metre, whereas previously it was 1.8, 1.9 metres. The reasoning behind this is that the applicants have now undertaken a detailed heritage design statement that they've submitted with the application, and it was considered it would be of more benefit with the relocation to actually enhance the setting, opening up views to this facade of Barty House. The sort of third change really is just in terms of the graduation of the wall, where it needs to be taken in on the corner to make sure that there are the correct visibility displays for the access. So where the wall meets Roundwell, it will actually need to be, you can see here where it actually curves in and it's pulled back. This artist's impression just gives a feel for what it would look like under this proposal. So you can see the wall being brought down in height, proposed landscaping scheme, and you can see there the more formal steps going up from the footpath. Again, the landscaping plan just adds a bit more colour, helps just illustrate the proposal in further detail. And the final element, which hasn't actually changed, is the wall which actually fronts Roundwell would actually just need to lose sort of the first top course of bricks just to keep it to the 600 millimetres required for the visibility displays again for the access. What I would sort of refer members to is, in terms of sort of officer comments, whilst the changes are material in terms of the way the wall is designed, obviously the professional view does remain the same, that these changes would cause less than substantial harm. And so therefore, obviously, that's the consideration. The officer's recommendation therefore remains that planning permission should be granted subject to conditions, legal agreement and the urgent updates. Thank you.
Thank you for that very clear presentation. I would like to call on, we have a number of speakers, and I'd like to call on Mr. Spooner for the objectors. Yes, do that. Before we do that, I'd ask my legal advisor just to set the scene for the rules and regulations for speaking. I hesitate, rules and regulations, not quite as strict as that.
Thank you, Mr. Chairman. Good evening, ladies and gentlemen. This is a short announcement for members of the public, and in particular for those who are speaking on any application or item this evening. As you've just heard, an item will be called by the Chairman, and the Planning Officer will introduce that item. The Chairman will then call the individual speakers. When you hear your name called, can you please come forward to the table in front and take a seat? To speak, press the middle button. You don't need to hold it down. The button will turn green and the ring around the mouthpiece on the microphone will turn red. You will have 3 minutes to speak, and I would ordinarily say you'll see your time counting down, but the clocks are not working this evening, so I'll be taking the time on my mobile phone. So when you get a terrible sound coming out of this, you know your time's up. Once you finish speaking, please press the middle button and then return to your seat. Now, there are visiting members here this evening. They are members of the council, but they do not sit on this committee. They also have 3 minutes to speak, but they have no right to vote on any of the applications. Thank you, Mr. Chairman.
Thank you. Mr. Spooner, please. Thank you.
Okay, the Bearsted and Furnham Society was bitterly disappointed that Maidstone Borough Council resolved to grant permission for this development at its meeting in April of last year. Even though there were significant planning and environmental objections to it and there was no means of access to the site because the Borough Council subsequently refused listed building consent to relocate the boundary wall. So far as we can ascertain, the Borough Council resolved to grant permission on the basis of its failure to have a 5-year housing land supply and its contention that contributions could be obtained from the developers towards the cost of providing additional school places at Southborough Primary School and at the new Langley Park Primary School. We find the changes that have now been made to the proposed access and relocation and reconstruction of the boundary wall to be just as unacceptable as the original proposals because of their serious impact on Barty House and on the local street scene. In addition, we are aware that with regard to the inspector's initial findings on the Maidstone local plan hearing, that Maidstone Borough Council now has a significantly more than a 5-year housing land supply. Therefore, the justification of granting permission for Barty Farm because of a lack of a 5-year housing land supply is no longer relevant. Furthermore, we are aware that all additional places at Southborough Primary School have already been taken up and that all places at the Langley Park Primary School are now already committed to all the children moving on to the new housing estates in the Langley Park area. Consequently, there will be no new school places available for children moving on to the Barty Farm development, and the planning application is therefore contrary to policy H121 of the draft Maidstone Borough local plan because school places cannot be provided within Bearsted or Furnham, and it will be highly unsustainable and unacceptable for these children to be forced to travel up to 10 miles away to find junior school places. The Society therefore requests that the Borough Council revisits its resolution to grant permission for this development because of the availability now of more than a 5-year housing land supply, because of the lack of any school places to comply with local plan policy H121, and because of the lack of a means of access that is acceptable in environmental and highway terms. We request that the application be refused because the development is contrary to policy ENV 28 of the Maidstone Borough-wide local plan, harmful to the setting of both the AONB and to Bearsted Village, harmful to the appearance of the special landscape area, and because a suitable means of access cannot be provided, and because the proposal is contrary to policy H121, because additional school places cannot be provided in Bearsted or Thurnham. We are aware that the application site is allocated for housing on the draft Maidstone Borough local plan, but it is a draft plan and it is within the gift of Maidstone Borough Council to delete this allocation from the local plan as a post-local plan modification, and we request it to do so. Thank you.
Thank you, Mr. Spooner. Thank you. Councillor Horn for Thurnham Borough Parish Council, please.
Good evening. Thank you, Chairman. I'd like to point out, first and foremost, if I may, a fundamental error in the first report. I see the officers have designated the building site as in the ward of Bearsted and in the parish town council of Bearsted. That is totally incorrect. It is actually in Thurnham parish, and I think that is relevant, as I shall demonstrate in a moment. Thurnham Parish Council, on whose behalf I come to talk tonight, has considered this application in vast detail, and I think has sent in well over 4 representations. They wish to register very strong objections to this. They are concerned, first and foremost, at the overall level of development, and that quite simply it's going to set a precedent which cannot be contained for development right up to and alongside the railway line. Indeed, the development itself, it proceeds, will lead to the loss of viable agricultural land and will therefore also form a coalescence between the parts of the parish of Bearsted and parts of the parish of Thurnham, which seems to have been forgotten on the papers tonight. It will therefore subtract, Chairman, from the rural character of the area and will, to all intents and purposes, complete the southeast urban extension up to and including Junction 8. I have to say, despite the words from KCC Highways, that the Parish Council does retain serious concerns regarding the proposed access and egress from this development. It's all the wrong place and situation. Sharp bend, bottom of 2 slopes, the topography restricts sight lines for oncoming vehicles, and it's adjacent to the unrestricted speed limit. The access, quite simply, is not suitable or safe for proposed car movements of 400 plus per day. I would remind members that despite the fact that you have a comment or no comment from KCC Highways, it is within your discretion, as set out in the Boughton Lane decision by the Secretary of State, to come to your own conclusion on the highway matter, hopefully based on the assistance of local knowledge. Again, the fact that the site is within the not yet adopted local plan is not material to the consideration of it tonight. Barty House, Chairman, and this is my main point in relation to this, sits in an elevated position, a rather grand, lawned setting, which is the whole feature of it. It's a listed building, and the changes will have an impact on the listed building, and the concerns of the conservation officer are well placed. It will give visual harm to the setting of Barty House, and indeed, for the very fact it's not linked to a potential development, it would have got short shrift already. We cannot see any benefit to the listed building by this, only harm to the setting of the building, additional traffic movements, and indeed there's going to be an increase in noise and pollution to elderly people who are receiving specialist care in the Barty, very high quality nursing home. There are road safety implications, especially for children. These are not addressed.
Councillor Horn, I think I allowed you to go well over your 3 minutes' time.
Chairman, I'm grateful as ever to your indulgence. It would assist if the egg timer had been working.
I would agree
but
with you. Yes.
Like most things, the technology at Maidstone has failed again. I'm obliged.
Councillor Ash, please, for Bearsted Parish Council.
Thank you, Chairman. Members. Bearsted Parish Council maintains its opposition to the development of 100 houses on land which, although technically in Thurnham Parish Council, it just extends the built-up area of Bearsted, basically pushing it into the open countryside. You've listened about the 5-year land supply. I'm reliably informed it's up to 6 years at the moment, or approaching 6 years of land supply. So this development isn't necessary. So if you don't build this, you don't have to bother with the wall. The development itself will put added traffic onto an already very busy road. I have the 2007, Jacobs survey for this particular road. Even then, 10 years ago, there were between 1,000 and 2,000 vehicle movements recorded per day. I just wonder what the figures are 10 years on. At this point, at the access point, the sight lines for the development are poor. And really, they cannot be improved a great deal. There's a sharp bend from the east, and it is from the east that drivers approach still in M20, A20 driving mode. Even though they should be doing 40 and then 30, they regularly get down to that speed. And there's a brow of a hill to the west, and suddenly, as you're turning out, a car appears, and you can panic. The local primary schools, Matchingford Primary, Rosacre Junior, Thurnham Infants, full. Initially, the plan was Langley Park. That's full, so we've been told. So now let's look at Southborough, which would mean adding extra traffic to Lower Stone Street and Upper Stone Street, which is already an air pollution hotspot. So there'll be a lot of Bearsted residents using that. I can remember Mr. Jarman saying that primary school children ought to be able to walk to school. None of these children would be able to walk to school. There is mention in the report of a bus service, the number 19. Hence, we need a better access, and the bus will go in. And Arriva's plans at the moment, we haven't seen them in detail, but the rumour is that the number 19 to Bearsted is to be discontinued. There may be an alternative which will go all the way around the houses, Matchingford, Bearsted, Grove Green, Downswood, and it won't be used because nobody wants a conducted tour before they actually reach the town centre. So I don't think the bus will be of any great use. I basically would urge members to reject this application. Thank you.
Thank you, Councillor Ash. Ms Scott, for the applicant, please.
Good evening. This application has previously been heard by Planning Committee in April 2015, where members made a resolution to grant the outline planning permission subject to a Section 106 agreement. However, at the same meeting, the listed building consent for works to the wall at the access fronting Barty House was refused, leaving the outline planning permission for 100 dwellings without agreed access. This application is brought before you this evening to consider the material changes only relating to the site access and policy material changes, as a resolution has already been taken by members to grant the scheme. The material policy changes include the involvement of the local plan, now at examination in public, and the adoption of the Kent Minerals and Waste Local Plan. The local plan inspector has published his interim findings, and this site remains a proposed allocation and, very importantly, forms part of the Council's 5-year supply of land for housing. Significant weight should be attached to this. Under the Kent Minerals and Waste Local Plan, consideration needs to be given as to whether the extraction of minerals from the land, in this case silica sand for construction purposes, would be economically or environmentally viable. We've provided an investigative report into this matter, which your officers have reviewed, and concluded that extraction would have limited contribution to sand supplies, and noted that Kent County Council has not identified this site as a preferred site for mineral extraction. In relation to the alterations proposed to the access, namely alterations to the existing boundary wall to Barty House. Significant further work has been carried out with heritage consultants to improve the proposed design of the rebuilt wall and frontage to Barty House. It is accepted by your officers that the works will result in less than substantial harm, and in such cases the public benefits of the scheme must be considered in accordance with the National Planning Policy Framework. This site provides significant public benefits through the provision of 100 dwellings, of which 30% will be affordable units. This, together with the significant weight that is now afforded to the allocation through the progression of the local plan examination, have added further weight to support the resolution to grant outline planning permission. Thank you.
Thank you, Mr. Scott. Councillor de Wigadeen, and welcome, by the way.
Thank you very much, Mr. Chairman, members. Considering the weather, happy Christmas. Members, when this site was first looked at in the local plan, I objected to its conclusion on the basis of numerous problems which were discussed, located in the special landscape area that forms part of the setting of the North Downs AONB. The Kent AONB unit have been consulted and they object to the site as it will be visible from the SCARP, but no landscape impact assessments have been undertaken. The site also contravenes ENV 28, and with well in excess of a 5-year land supply, this cannot and should not be disregarded. It is clear that the access proposed is not safe. The bare minimum legal visibility criteria can only be met by destroying the curtilage-listed wall at Barty House Nursing Home. The case officer agrees that the proposals will cause significant harm to the setting of the listed building. Moreover, pedestrians will be expected to exit the site at this point and will have to cross the road directly on the bend with poor sight lines because there is only a pavement on the opposite side of the road. There is no safe way to cross this road here. Irrespective of no objection from Kent Highways, as Councillor Horn said earlier on, highway safety can be used by this committee, as confirmed by the inspector of the Borton Lane appeal. Local residents are very well aware how dangerous it is to cross the road here. By far the biggest concern, and has been mentioned before, is the well-evidenced lack of primary school places. The latest figures available show that not only was Thurnham Infant School completely full in September 2016, but that the next two schools, nearest schools, Maginford Primary School and St John's School on Grove Green, both have a reception intake above that normally permitted. All three nearest schools have no places. None of them can be further expanded. The proposal for contributions to expand Southborough Primary School is just not acceptable, as that school is not in the area and it too already has in excess of its permitted numbers, even after the expansion to two-form entry. It beggars belief that we could expect primary school-aged children to travel right across town on Maidstone's increasingly and more clogged roads at peak time, all by cars. The officer's report calls this a sustainable development, but we all know that's the complete opposite of sustainable. When Cabinet put this site forward for Regulation 19, it was the requirement to include primary school places within Bested and Thurnham. The policy criteria for this site, H121, has not been met. It is also not met by the already full Southborough Primary School, which is the current proposed mitigation. It would be negligent if this application were permitted with no deliverable plans in place whatsoever for primary school places. Therefore, this site should be refused on the basis of harm to the countryside in contravention of ENV 28, harm to the setting of the AONB, harm to the listed building Barty House, highway safety, and harm to the primary education provision. Perfectly on time. Thank you very much.
Members of the audience, I would ask that you do not clap. This is a place of serious discussion, and I don't want members to be given full chance to speak. I realise emotions run high sometimes, but please forgive me for saying this, but please no clapping in this room. Thank you. Coming, please.
Thank you, Chairman. Evening, officers, members, ladies and gentlemen. I won't say good because it's snowing outside. Right, the mitigation plan for the lack of school places was grounds for a refusal of a few houses at Apple Tree House, just along the road from this development. South Borough School was not in the mitigation plan for Bearsted and Thurnham in KCC's commissioning plan for education provision in Kent, 2016 to 20. The bus service is being reviewed with a plan to reduce it, as referred to by Councillor Ash just now, and this will impact on the sustainability of the development. As Maidstone now has significantly more than a 5-year land supply, that renders the development unnecessary. You may have seen the article in the Telegraph this week, which was a survey of 1,200 ward councillors, 72% of whom felt that the planning system was too weighted in favour of developers at the expense of local communities. The photographs issued just now, as we came in, show that, well, some of the photographs are much older than the current situation, showing in photographs 4 and 6 a much smaller sign. The sign that is currently in place is much bigger and reduces the visibility splay even more. Obviously, as previously mentioned, there's a loss of agricultural land, and it impacts seriously on the setting of the Kent Downs AONB. I won't go into any further details because most of it's been covered, being tail end Charlie again. Thank you.
Yeah, absolutely right. I just ask Mr. Bailey just to comment on a couple of items that have been mentioned before we go into the general debate.
Yeah, just to address sort of 2 points that really came out to me from comments coming there. One, Borton Lane appeal issue. I just wish to address that point. That decision has been quashed by the High Court. There is a public inquiry reconvening in the latter part of the summer, so there isn't a decision on that basis. It is for reconsideration. That is the legal stance that it is. So there isn't a Borton Lane decision that is awaiting a public inquiry reconvened. Members need to bear that in mind. Regarding the Council's 5-year supply position, just like to reiterate, and this has been a consistent approach through the EIP examinations, the Council is relying on its 1st of April submission. Now, in front of, this has been circulated, this was the housing topic paper that was submitted at the EIP. Now, that sets out the Council's 5-year housing land supply position, which effectively demonstrates we have a 5-year supply. It's at 5.12, so there is in excess of 155 units. Now, during the EIP examination, we did submit updated housing topic papers to give a general direction of travel, but the Council's position, and this position is set out in the report, the clear position is the base date of 1st of April 2016, and that's demonstrated by the housing topic paper. So in terms of these issues, but I've heard lots of people saying 5, 6, in excess of those years. The Council's position is as set out on the papers as 5.12. There is a general direction moving towards it, but we're not changing that position. That's the position we take for EIP, for public inquiries, and that needs to be very clearly set out. So whilst it's improving, the whole point of the EIP issue is to send us in a direction, and we're satisfied with the way we're going. So it is improving, but the position, the formal position, is as I set out. I would also bear in mind that taking into account this site, H1, the site allocation H121, as set out in the housing topic paper, which is clear and is updated by the September update, does include Barty Farm in the 5-year delivery and the 10-year delivery, and it includes 80 units within the 5-year supply and 20 units in the 10-year supply. So that's what contributes to the 5-year supply, and that's the issue that the inspector has considered during the updates in terms of the robustness of where our supply sits. So I just want to address members on facts and not assumptions as part of the decision-making tonight. And I think I'll hand over to the Chair. Thank you.
Thank you, Mr. Bailey, for that clarification. Just remind members that there are urgent updates on this agenda item, which I think you've all seen. I have 3 members who wish to speak. First of all, Councillor Prendergast. Then Councillor.
Thank you, Chairman. I wasn't part of this committee when this application was last heard. In fact, I wasn't part of this council. And I know Mr. Bailey has just given us some clarification on the 5-year housing land supply, but I still need some more. The officer's report on the 26th of April states that we had 3.3 years housing land supply. And you've just said, as of the 1st of April that year, it was at 5 years. So was the correct information? Was there any update to the committee members to enable them to make an informed decision that night? Was it complete? I need to know that. That would be helpful for me. And I know you say we're still working on the 5-year land supply, as in the housing topic paper, but Mr. Jarman at SPSD was quite clear that the latest figures show over 6 years. So if that is the case, does ENV 28 then take full weight? I'd just like some clarification on that. I've got some other things that I need to talk about. There seems to be an urgent update missing, Mr. Bailey. I was sent this afternoon an email from Nicholas Abrahams regarding school places. Powerful stuff, very strong objections regarding delivering school places for this development. I can't see it on this update, but it just leads me to ask, where are these children going to go to school, given this email? How are they going to get to school? Because there just doesn't seem to be any provision there. So how are we going to meet the requirements of paragraph 72 of the MPPF to make sure that the needs of existing residents and future residents are met, given that all these schools are oversubscribed and there is a considerable shortfall coming up over the years? Also, paragraph 32, which states that key facilities such as primary schools should be within walking distance. Well, there are no schools within walking distance, or certainly KCC have said they can't provide them, so I would like some reassurance on that. A number of speakers have mentioned the site criteria for policy H121 in Regulation 19, which asks for contributions to primary school education in Bearsted and Thurnham. Southborough Primary School is not in Bearsted and Thurnham. I think one of the speakers mentioned that the Southborough expansion has already taken place and the school is full. So clearly the mitigation that was proposed in H121 is no longer there. And in my mind, that is a material planning consideration. I'm not finished. The heritage aspect of this is concerning me. I don't think that will be a surprise to anyone. Given the level of objection from our own conservation officer and the case officer on this, I am absolutely surprised that Historic England have not been consulted. I looked through the planning portal very quickly this afternoon, and I can't see any comments from Historic England. And I know the case officer in her report has said that, there is relevant case law that applies to matters such as this. I'm not an expert. I only know one or two. I won't bore you with Barnwell Manor, which I've quoted over and over again, but that says any loss or harm to heritage assets or their setting, be it substantial or less than substantial, requires the most compelling justification. And looking at what happened in April last year, there was serious concern there because the second part of the application was refused. Also, I've come across others with other case law that says in order for the requirements of the planning and listed buildings and conservation areas regulation to be discharged, the views of a body charged with specific responsibility for the nation's heritage ought to be sought. That is Historic England. Bearing in mind the Conservation Officer's objections, and they're really strong objections, again, very powerful, and the case officer's reservations on this, I would have expected to have seen something from Historic England. So I'd like those questions answered, and then, Chairman, if that's okay with you, I'd like to come back. Thank you.
Right, I'm going to work in reverse order because those are the ones that are the most poignant in my mind at the current time, and then my colleague will pick up any issues that I forget to mention. In terms of Heritage England being consulted, they're not a stat consultee on a proposal for a Grade 2 listed building. So on that basis, there was no requirement to consult them. Likewise, there was no requirement on the other application. The Conservation Officer has given a very clear view, and he said there is a degree of harm arising. He contributes that to be less than significant, less than substantial. On the back of that, he has concluded that you have to weigh the 134 MPPF test. So on that basis, there is clearly no need to involve Heritage England on that base. They defer their decisions to Mike Parkinson, who was our Conservation Officer, who's now left, and he has given his very clear views on that basis, and they're set out in the report. And notwithstanding those issues, in terms of those issues were considered in a lot of detail in the previous application. Regarding the issues in terms of the school issues, they are and were clearly addressed and set out in the previous application that was a resolution to approve back in 28th of April. They are detailed in the Appendix 1 committee report that's set out. And obviously members considered those when they resolved to approve the application on that basis. And I think revisiting those issues at this current time, accepting the letter, and I think the case officer did omit to address that issue from Nick Abrahams, because I did see that email that came in later and the case officer was meant to update. So apologies on that basis. There is a letter. It does set out in the committee report. It's the sustained objection. It's a continual objection based on their previous objection. So apologies for member that wasn't relayed, but the issue is the same that they objected previously. But that objection, members considered that on the 28th of April. That was considered, but members still considered to resolve to approve the application in light of that objection on that basis. And on that basis, that situation hasn't changed. Regarding the issues in terms of, I've said quite clearly in terms of the interim inspector's findings, the position on housing land supply is improving. The Council is at the current time going back to Mr Mellor, as I've previously said, setting out our understanding with AON, with taking out some of the sites. And let's not forget, the inspector recommended 3 sites to come out. And on that basis, those 3 sites are the sites that we're actually taking out of our supply. Now, this site wasn't included in that 3-site allocation. It was in terms of the sites at Borton Lane, the other site in Borton Lane, and Syngenta for housing allocation. So those 3 sites have come out. They come out of our 5-year supply. What we're doing is going back to the inspectorate, to Mr Mellor, and saying, this is what we think you're saying. This is what we think the conclusions are. Until we've had confirmation back from Mr Mellor that that's the interpretation of his interim findings, you know, Mr Jarman has a duty to update members, and his duty is that we're going in the right direction. But let's notwithstanding that, the Council hasn't got a formal position on what the supply position is. What we're saying is that the formal position is the 5.12, which is the base data from 1st of April. And the reasons why, one of your other questions that we go back, is we use the 1st of April as an AMR, Annual Monitoring Report. So that is a base date from the 1st of April. It isn't produced on the 1st of April, and hence why the application came on the 28th of April. At that particular time, the AMR hadn't been completed. But because policy advises you to do an AMR on a base date, 1st of April each year, you know, and the Council haven't been doing AMRs for the previous 2 years. So subsequent to this, you won't find an AMR for the previous years. So the issue is we did one in effectively for 2016-17, which showed our position, because that's we were going to Reg 19 and going to examination. So that is our base date. So you take the base date 1st of April and project it forward to the 1st of April 2017, when we will do another formal AMR, and it will set out our formal position. What we've tried to do is to give the inspector a guide to show, and to members to show where we're going, the travel of direction. And that is what it is. That's what interim findings are. They're not formal findings, they are interim. They're material, but they show in terms of what the inspector's thinking. So they are significant, but it's a direction of travel. So hopefully I've answered the questions on the issues why we use 1st of April. Now, I think it's clear in terms of where we should apportion EMV 28 in terms of weight. The emerging local plan is gathering momentum and is gathering, as we set out in the report, significant weight. What that does is extends the Maidstone urban boundary in this location to include this allocation site. So on that very basis, because Council resolved to approve this site at full council and progress to Reg 18 and submission, and the local plan inspector has not raised an issue with that site, EMV 28 is carrying less weight in this locality, because what has been happening is that significant weight has been attached to the emerging policy. What that does is extends the settlement boundary. EMV 28 on the local plan effectively excludes it. So given the basis we're now front-loading the plan, in effect EMV 28 is now taking a, if you say, back seat in this particular location because it's clearly identified in the emerging local plan to extend it. So on that basis, less weight. I'm not saying it's not material, it's part of the development plan, but it carries less weight in this application purely because the fact the settlement boundary extends. So I'd also add to that basis, on the back of that and the back of the resolution to approve by members, again, very significant that they considered all these matters previously, and what this report is coming back to you is on the basis of the changes, which, you know, as I said, as case law dictates, where there are material changes, we should bring them back. We've brought them back on the basis of the 5-year supply. That actually reduces the weight to EMV 28, as I've said. And actually, we're attaching significant weight to the emerging local plan, which allocates the site. That deals with that point. There is the emerging Kent and Minerals Waste Local Plan. It's part of the development plan, so it is, as part of section 38.6 tells us, we must consider it. So we have considered it as part of the update, and then what we're moving forward to is then the setting issue in terms of the wall, and that's something in terms of what members need to consider is those changes to the wall that has occurred from when you previously considered it. So the location is the same. The wall is not moving from where you previously resolved to approve. What is changing is the introduction of steps and a lowering. So those are the key matters. Those are the changes that I've just outlined that members are considering. So all those other matters were resolved to be approved. Now, hopefully, I've picked up most of those issues, but if I haven't, then Amanda will pick up the rest of them. Sorry to labour the point, but I think it's very clear where members need to make their decisions tonight. I'm not trying to force you into a direction, but you need to be very clear in terms of what are the considerations.
Thank you. I think that's very clear. Councillor English, please.
Yes, members need to be very clear what we are and what we aren't doing and to make decisions on planning grounds. We've made some very good decisions as a committee. That's not to say which way they've gone, but ones that are very firmly argued. We see an appeal decision on the papers tonight in relation to Lenham, where we refused an application the officers recommended for approval, and the committee had very firm grounds to refuse that. We've seen another one, which I won't refer to by name, but where the committee did not make a refusal on grounds, and it stood up, or even could be argued, and the consequence was the residents went home very happy on the night, and that couldn't be made to stand up. So I'm not worried about the cost award, but I am worried about actually making decisions that stand up. I'm also concerned that we make those decisions in line with what planning and material considerations dictate we should do. This application was heard, or the predecessor application was heard in April last year. A number of the issues that have been rehearsed tonight were rehearsed at length then. If something has changed since then that should be taken into account on one side of the argument or the other. But what we shouldn't be doing is making a decision that is blatantly at variance with the previous decision, because that will not work. We may like to do it, but it's not going to happen. We have to bear in mind that this is an allocated site. The inspector has just reviewed up to an interim stage our local plan allocations and has so far decided this site was rightly allocated. Now that's interim, and of course there may be modifications, but that is the material situation at the moment. Similarly, we have a situation where at the moment we have a 5.12 housing land supply figure. We may end up with 6 if nothing changes. However, if we just decide to start removing components of that 5-year housing land supply, we pretty soon won't have a housing land supply. So we need to be very, very certain if we start removing those bricks, because the consequence will be that we, A, won't have a local plan, and B, those sites that have been removed or are subject to appeal in the very near future will suddenly become vulnerable again. So we will have that situation where the implications are not just limited to this site, but are very, very, very wide. So if we do make that decision, there needs to be a very, very firm reason why this site is unique and can be withdrawn from that 5-year housing land supply without affecting the broader situation. And there needs to be a unique situation, and frankly, I'm not seeing it. Now, finally, in relation to highway issues, the Bolton Lane decision was quashed. However, it's a little more complicated than that. But what I would say is that members of this committee need to realise that organisations like North Lewes Residents Association, for example, which has done sterling work over the last few years, and inspectors are in a different position than a public authority. They can make decisions or make representations in a freer way than we can. If a public authority decides to recklessly decide to make a highway decision in contravention of the highway authority's position, we, as a public authority, are in a different position than a residents' association or a parish council, or indeed the inspector, who do not have to abide by the same careful considerations we do. So I think members do need to take that on board. And that is what the inspector chose to introduce the highway issue in Bolton Lane, because of particular circumstances, taking into mind representations from NRLA. That was okay, and there was no risk of a costs award against the inspector, obviously, because he was hearing it himself, or against NRLA not being a public authority. We are not in that position. Our decisions need to be based on evidence. And finally, having been involved with many applications that involve listed building consent, the officer is quite correct about the weight to be given to the conservation officer's point. However, that does not mean that I'm happy with the listed building application. I will come back to that later because there are points on that, but we are discussing the planning application at the moment. But I have to say I do have some serious reservations about some of the issues about the listed building consent, but I'll come back to that later.
Thank you, Councillor English. Councillor Borton, please.
Thank you very much, Mr. Chairman. And like Councillor Prendergast, I wasn't a member of this committee and I did not vote on it in April last year. So I come looking at this application tonight with somewhat of a fresh view. And while I accept the point Councillor English takes, and I have read through the decision that was made in April, by this committee. I'll be judging my decision tonight on all of the evidence in front of me, both April's decision and also the material changes which we have to consider. Now, I think the speakers all raised points which are incredibly important to this committee, and include some planning reasons which we have to consider, and also some practical issues which I believe we have to consider as well, but also have, in my opinion, certain grounds for refusal. And what I'm talking about specifically here is the schools issue. So my question is incredibly specific on this, because my personal view is that we're looking at this for the first time. There are grounds for refusal on the basis, as Councillor Prendergast mentioned, on the issue of access to primary schools and primary school provision in the area. However, I accept that this was considered in April by this committee. So my very specific question to the officers is, can this committee refuse this application based on matters it considered and perhaps came to a different view in April on, or when we vote tonight, must we consider the material changes only? And I think that's an important question for the public to understand, and a few of us as newer members of this committee as well, and I think that is absolutely crucial and to the heart of the issue tonight. So I'd appreciate the officer's response to that specific question, if that's okay.
Yes, Mr. Spade, I think this is a very important point. So.
It is an important point. The issue that members have got before them, this is an application before members to make a decision on. It has a resolution to approve. Therefore, members will be looking at all the application. And what members have to consider, and the reasons why this report has come back, is those issues were considered at the previous report in 28th of April 2016, and members resolved to approve the application on the basis of that information. Mr. Crick had the same arguments that he put forward on that. There was the same letter of objection, and that still is the same now. So the objection that he's raised is the same now as it was previously. Members considered that, and they still resolved to approve the application. Now, what you're getting to, I'm not going to turn around to say members cannot. What you're into the issue of whether it's reasonable to come to a different conclusion now from that which you previously raised. Now, the issue, and I hate to raise this issue, it comes down to costs, because it comes down to defending the council's position at an inquiry or whatever appeal that is taken forward. Now, what someone else will be deciding is to say, same issues were considered in April, same objection letter, re-emphasised tonight, different decision. Why? Now, is that reasonable behaviour or not? Because, and I don't say this in terms of, because I've been caught out by members before, it's not against members. Unreasonable is what we call in the cost award scenario as set out in the MPPG. So there are definitions set out of what constitutes unreasonable behaviour on the council's behalf. Now, the issue is, and quite clearly to my mind, is that if those circumstances haven't changed and you previously accepted those and you went on the scheme to resolve to approve, to my mind it would be very clearly unreasonable to raise them now when that situation hasn't changed. And that issue is where your officers have to defend the appeal, and that's where you get opened up to a glaring extent of a cost award. And that is where, you have in front of you the decision where, I won't go into it, but where you can't defend that decision, then you're opening yourself up to a full award of costs because you've entered into a public inquiry on the basis of, and these are considerable costs. For a 100 housing scheme, it's considerable cost at a public inquiry. I think everyone knows exactly how much they are. They're extremely expensive, where all sides have to get relevant evidence into sight. So hopefully that addresses your issue with regard to whether it's reasonable or not.
Thank you for just quickly, yes.
So on that basis, summarising up what Mr. Bailey said, by that definition, if we were to offer an objection based on grounds that were considered, as my question was, where the circumstances have not changed, it is your view that that would constitute unreasonable, an unreasonable behaviour, for want of a better word, at a council. So that means that to some extent this committee is very much bound by the view, whether we like it or not, that was taken by this committee in April. I just thought I'd explain it clearly.
Councillor Burton and then Councillor Howard.
Thank you, Chairman. I'm glad Councillor Bolton asked that question. It was on the tip of my tongue as well. There is a part of me that sits here and says, knowing full well how expensive these costs potentially are, do we prefer to potentially swallow that and actually walk out of here feeling we've made a decision that we can base our integrity on? I'm not comfortable with what I think is, and what I think many of us in this room think is a serious issue concerning primary school places. I do have a quick question, although I think I do kind of know the answer, whether or not it constitutes anything like a material difference, given that we are well into a fresh academic year, and whether actually the issue regarding school placements and availability at Southborough has changed in that time. All that aside, I think the thing that we really should be discussing, that we've barely touched on yet, is whether or not, if we move to grant this application, we truly think it can be realised because of the considerations we must give subsequently to the access. If, and only if, we can leave this room truly believing that this is a sustainable development, then I think that we have to consider that giving potentially 100 families homes is of greater benefit to the people of our borough than keeping a wall that has stood for some considerable time in its place, bearing in mind as well the careful consideration subsequently that has been given by the applicant to the manner in which that can be moved. My only question, just to summarise, is whether or not it is a material difference, the fact that we are best part of a year on now, and whether that makes a difference to the mitigation concerning Southborough School.
James, do you want a quick...
Yeah, I'll let Amanda answer the material issues, because I don't... It's Amanda's case. On the basis of the issues of the access, just want to clarify one point. The access issues were as considered previously. So in terms of the access, as I said, the location of the wall, that wall was as considered previously. So in terms of sight lines, the lowering of that wall, that was considered. And likewise, in terms of the setting issue, the issue that you are really considering is, in terms of the setting, is what are those differences between those plans that Amanda showed you in terms of the wall heights, the slightly lowering of the wall and those steps. Those are really those issues. Access doesn't change. Positioning of the wall doesn't change from that approved. I just sort of want to clarify that issue, and I think Amanda will come back on the materiality issue that you raised.
I think we... Sorry. Thank you. I think, as we said, at the last committee, the issue of school places was explored and discussed in a lot of detail. KCC have obviously just reaffirmed their views, and I do apologise. I didn't find that out until literally the last moment, and I'd meant to verbally just update you on that. The situation with school places, it is obviously always evolving. There is always movement between schools for a whole variety of reasons. And I do accept the concerns, obviously, of residents. In this instance, the other arm, if you like, of KCC had requested the contributions to Southborough School under a Section 106 agreement. And And so that obviously was before members in April. Now, I hadn't actually received an update from them in terms of the contributions or the direction of those contributions. Their objections on the commissioning plan, there is, with that, it is very much a rolling document. It's a working document, so they review that every year. So things are constantly moving. And I think with other developments coming on board, other contributions coming on board, the situation can be fairly fluid. I honestly don't believe that any of the comments reaffirming their views actually fundamentally sort of changes the approach that we've obviously taken before on that. Thank you.
Thank you. Councillor Harwood, you've been very patient.
Thank you, Chairman. We've really got to move this matter forward, and I think we need something on the table, and I will do that. I mean, we have to approach this with our heads and not our hearts, effectively. I tried and failed in this council chamber to have a housing figure of 8,200, which was what the Kent Structure Plan stated. We ended up with nearly 10,000 more. I lost that fight. It was outvoted. That's democracy. We are where we are with the housing figures. However, if we jeopardise the 5-year supply, as we could do if we start to subtract from that agreed figure, we will be back into the same mess that we were in last year, where we were permitting many schemes that did far more harm than this application. Far more harm to landscape, far more harm to biodiversity, far more harm in terms of road safety and traffic generation. And we were permitting schemes which did not have the design quality, which were not sustainable. We have got a semblance of control once again, and that is why this application, in terms of its quality, in terms of its sustainability and so on, is chalk and cheese compared to schemes, many, which are going up around this borough, it's got to be said. In terms of numbers, Bearsted and Thurnham have taken a huge amount of development, but most of it was in the 60s, 70s, 80s. In the current local plan, there is relatively few new developments going through, certainly far less than in many of our urban wards, which are taking thousands of units rather than just over 100 in this case. In terms of the heart issue, I've worked on Barty Farm. I used to dip the sheep on Barty Farm. Of course, I would love Bearsted to stay the way that it used to, but it's not. And development is accelerating and is snowballing. But what we must do is deliver development of quality. In terms of the issues that have been talked around education and so on, we are not the Education Authority. There is legislation which states that those other parts of the jigsaw are going to be delivered, and all of the arguments that are being used here can be used with knobs on in Harwich, can be used with knobs on in Marden and other areas where we are getting, vastly more development. So, with that said, we need to essentially cement the principle we established back in April, which is to grant permission again, in my view. And I think actually we've moved some way forward. This scheme, in terms of some of the landscaping proposals, some of the hard landscaping that's coming forward as an element of the scheme, is superior in many ways. So actually, there is a material improvement. But, in basic principle, I would far rather this remains a field. Of course I would. But it won't remain a field. It will be developed, but we will lose any control and we won't be able to demand the quality and the sustainability that we are getting here. So I therefore move that we do grant permission. Thank you.
I have two more speakers, so I'll invite those two more speakers. Councillor Greer first, then Councillor Cox. Then we'll...
Thank you, Chairman. I think most of what I was going to say has been covered by Councillor Harwood. We just need to move this forward. We're not here to reconsider the previous application. As much as people would like to, that is not on the table. It is quite a simple application in front of us, which is relating to the wall. I know people are very sensitive about certain aspects, but if we do decide, or we think we can decide to start taking out applications which have been approved in the past, we are in big trouble. There's no doubt about that. And I think members need to be minded and look back in the past where we've made some rotten decisions and we've really been hammered with costs. So, as far as I'm concerned, the wall, yes, that is very, very important. But we need to ensure that the parts of it which are dismantled are replaced in a sympathetic manner, that the right mortars are used and that it is made to look good. I think the other interesting thing, looking at the artist's impressions, always amused me. You know, the artist here must have gone a bit flappy with his yellow pen and so forth, putting these big trees and so forth in. But likewise, looking at the photographs of the existing displays and what have you, I do believe this is a far better outcome. Thank you.
Councillor Cox.
Thank you very much. It's just a point of clarification. Because in item in section 9.1.4, it actually specifies Southborough Primary School. If they say they can't take any more people at the point at which the development is delivered, will the money go nowhere, or does it have to go to their come hell or high water? Because I don't think I've ever seen any briefing notes when you go to buy a house and it says, come to this wonderful development, your children will have to travel 6 miles to go to school. I'm not saying it is 6 miles, but I'm just saying that you would assume that because I bought my house here, my contribution is going locally. And if we can't put additional schools in, or we can't put the appropriate size of schools local to encourage them to be able to walk or to have a very low distance to travel, I think it's a bit tongue-in-cheek when we say, well, build them here, but we want you to go to school over there. So does it have to go to Southborough Primary, or are we going to be caught with our pants down because if the information we've been given is that there is no more room, we can't build any more classrooms there for no more intakes, we're going to lose that injection of cash? Can I just have that as a question first? Answer, rather.
I mean, in terms of the 122 and 123 tests, we're bound by those. So the reasons why we have to be specific in terms of Regulation 122, the SIL regulations, is because we've got to say that the needs of the development, the monies that we collect, mitigate the impacts of the development. So the reasons why we put the specific school locations is to meet the 122 SIL test. So that's why we have to put it in there. Now, as my colleague said, the issue is quite fluid in terms of the commissioning plan that gets updated in terms of school numbers and in terms of catchment areas. So my personal view is that money wouldn't be lost because by the time the development comes forward and is occupied, we could be looking at a number of years in the future and then that situation may change. So my personal view is that the monies wouldn't be lost because KCC will quite clearly be saying, OK, where's the money for this scheme and I'd like to put it into that school for a particular purpose. So I think it won't be lost. As I said, it is an evolving and evolutionary situation with schools and they do change on a regular basis.
Well, may I possibly ask legal then whether or not it is at the ability of this committee to actually change any specific recommendation to either Southborough or indeed to Mapleston Noakes? This might be delayed and then come back, and we must be careful. As I've pointed out before, we're looking that we're having our local plan come towards. Now this is crossing the T's and dotting the I's. We as a committee must be careful what we're passing.
My view, if you go to section 106, which says, and this is a requirement because we don't have a sole schedule as yet, we have a pooling restriction of 5 developments. Now, if the section 106, and we have to be specific within it, says that that money will be spent on that school, well, then that money must be spent on that school. What you could do, I suspect, is because there have possibly been changes in the education thing, as has been pointed out by the officer, is that you could delegate to the officers to go to Kent County Council and, well, say, well, to which school, if it passes the SIL test, can this money be used on? And that is what would be used in the Section 106. If I'm not mistaken, I think they previously said, well, the local schools are already at capacity, so therefore pushing out. Now, obviously, some of the other schools are now at capacity, but if the catchments keep changing, it may be that other schools get brought within the catchment. So therefore, I would probably say rather have that delegated to officers to go to KCC as to where that money should be spent.
If legal consider that, Mr. Chairman, the correct way of doing that, I would hope that the two proposers, the proposer and seconder, would agree with that change, because it seems to make common sense, which I hope is what I speak.
We can't risk losing the money that is needed to provide the education places by being too specific and not allowing for that flexibility.
Well, the way 106 is, well, I'll be frank, we try to put an element of flexibility within a Section 106 where we turn around and say that will be spent at a particular school or within 1 mile or 2 miles of the development, because it has to mitigate the impact of the harm caused by the development. You can't just lump it on the other side of Maidstone, because that ain't impacting. So what we try to do, and some developers accept it, a lot of them don't, where we turn around and say it will be used on such and such a school or within 3 miles of the development.
Mr. Chairman, I think that we have to a certain extent, allow the officers' delegation in conjunction with KCC because of the fluidity of the commissioning plan. What we don't want to do is get caught out by having a situation where the money that's needed to provide school places can't be provided because we've slipped up in the committee. So I think I prefer legal's original formulation.
In which case, Mr. Chairman, I did have a last thing, and it really was about the wall, because that's what we're really looking at here. Well, one of the considerations. We have some steps coming down from a higher level to the path level, correct? I always thought that where steps come down towards a highway, they had to have something at the bottom of them to stop people going into the highway. They seem to be there for no real reason of linking anything from the house, like an exit or whatever. So are they ornamental, or are they actually guiding people down as this is the exit out of Barty House?
Councillor Cox, I mean, where my colleague's arrow is pointing, there is a footpath there proposed, so they don't actually come straight out onto the vehicular access. So they'd come out onto a pedestrian access in terms of where they're... So in terms of what I would regard as being safe, I would consider that to be safe because they're coming onto a non-vehicular trafficked route direct.
So it's subject to the... Councillor Harwood, you're happy with the amendment, presumably, or the revision to... It's not exactly an amendment, but...
As long as it stands up legally and we're not
that's fine.
getting ourselves into a mess, okay. I'm happy to support that change.
Good. Okay. So there is a proposal and a seconder on the table. I'm going to move to the vote now, so I see no more hands. Sorry? Oh, I don't use that system here, sorry. Do you want to speak? I really want to go to the vote, because we've been spending a long time.
My understanding of it, just very quickly on the school, is that in April, when this council voted to approve this, the mitigation was for expansion of Southborough Primary School. That expansion has already taken place, and the school is oversubscribed. I'm finding it really difficult at this stage to put mine, to approve or to recommend an application where we don't know where the children are going to go to school, because KCC couldn't be clearer that there is no room for expansion at any local schools within 3 miles. Southborough had not been expanded back in April 2016. Chairman, I would like to move an amendment to refuse this application on paragraph 32 and 72 of the MPPF, policy not compliant with policy H121 of the emerging Maidstone local plan, and also, given the level of concern from our own conservation officer on the setting of the historic building with the changes to the wall and the steps, because it does completely change the setting of it. And it's not to the benefit of this asset, it's to accommodate what I consider to be unsustainable housing. So against the Planning, Listed Buildings and Conservations Areas Regulations 1990 and the relevant NPPF paragraphs. And I'd like to call for a named vote, please. Thank you.
Before you do, have you got a seconder to your motion? Do you have? Does anybody wish to second that? Because if not, it falls, doesn't it? And it falls. There's no seconder. So we move back to the original proposal. I'm going to ask for a show of hands in favour of the recommendation. It's the recommendation as put forward, subject to that, the delegation. And the urgent updates, indeed, yeah. Can I show a show of hands on that?
2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12.
Against? There's 2. Thank you very much. I know it's a difficult debate. Oh, you should do. Is there anybody missing?
I thought it was 11. I thought it was 11 against and 2
in favour. Yeah.
11 in favour and 2. That's what I worked it out. But you said 12.
1, 2, 3, 4, 5, 6, 7, 8.
Sorry, can we just do the count again?
13. There's 13 round the table, so it's 11 and 2.
In favour?
Sorry, can we just put your hands up in favour again? I do apologise.
Oh, sorry.
As you voted twice.
So it's 12. Yeah, 12, yeah. And against?
As this one. I'm sorry, I know it's thank you all very much for that. It's not an easy subject, and we'll move on. We'll move on to agenda item 14, which obviously is related, but it's application 16/506735, Barty House Nursing Home, Roundwell Business Centre. This listed building application.
Okay, so this is the accompanying listed building consent application for the outline. At the meeting held again in April last year, members actually refused the listed building consent application for the proposed works to the listed wall. So the scheme before members this evening is the amended proposal for undertaking of the works to the wall. Again, I reiterate that the relocation, the siting of the wall is as per previously considered, but the difference is how the wall will be rebuilt. So, Section 16 of the Planning, Listed Building and Conservation Areas Act 1990 requires local authorities to have special regard to the desirability of preserving the building or its setting, or any features of special architectural or historic interest which it possesses. So this, you will see, is the sort of theme that runs through the listed building consent report. I'll go back to the changes just to refresh everyone's memory on the now proposed scheme with regard to the setting of the listed building. So the differences between the scheme which members previously refused, existing wall as it stands, were the fact that the wall was going to be rebuilt to approximately the same height as existing. There was going to be no break with regard to any pedestrian footway. So you're looking at a wall again of about 1.8, 1.9 metres in height, reusing as many materials as possible. So the amended scheme, again, we have the insertion of the steps onto the public footpath. We have a lower wall, so you're looking at a 1 metre in height wall rebuild, and a more sort of graduated drop to Roundwell with regard to the visibility displays on the corner of the access. So the officer's recommendation on the papers obviously is one for approval of listed building consent, which was the previous officer's recommendation as well last year. Thank you.
Oh, thank you for that. It's a very precise introduction. I'd like to call upon Mr. Spooner for the objectors, please.
The Bearsted and Thurlow Society has consistently objected to the demolition and repositioning of this boundary wall, which forms part of an essential feature in the historic setting of Barty House. We request that this latest application for listed building consent to reposition this wall be refused, because the realigned wall will create substantial demonstrable harm to, firstly, the setting of Barty House, because it will inevitably be of a new reconstructed appearance, be lower in height than the existing historic wall, introduce alien pedestrian steps which will destroy the integrity of the wall, and most importantly will substantially reduce the lawn area in the front of Barty House, which is so important to maintain its historic setting and appearance. There will also be demonstrable harm to the local historic street scene, because it will lessen the sense of enclosure and harm the setting of Barty House in a very attractive and historic approach road into Bearsted Village. In addition, we should like to point out that in our view, applications for listed building consent should be determined solely on their architectural and historic merits. Therefore, the argument put forward by the applicants that there are no public benefits, that there are public benefits flowing from the proposal, because the realigned wall will enable access to be provided to another proposal to build 100 houses at Barty Farm, is irrelevant and should not be taken into account. If, as it should, listed building consent is refused for the realigned wall on purely architectural and historical criteria, and if Maidstone Borough Council still resolves to grant permission for the housing at Barty Farm, which it has done, it follows that an alternative means of access will have to be provided for the housing development. This is a problem for the developer. It is not the responsibility of Maidstone Borough Council to find suitable means of access to development sites, and it should not compromise its statutory responsibilities to protect its heritage assets to do so. Thank you, Mr. Chairman.
Thank you, Mr. Spooner. Councillor Ash for Bearsted Parish Council.
Thank you, Chairman. Not too much more to add to that. Bearsted Parish Council still maintains its opposition to this development of moving the wall. In our opinion, it would cause harm to the setting of the Grade 2 listed building. Most of these changes are just cosmetic, basically. I don't think they overcome the visibility problems on leaving the site. The relocation is not essential in terms of repair work. If the wall needs maintenance, it can be done in situ. We feel that the proposed work introduces an element of urbanisation, i.e. a surface road and a footpath, into what is basically a rural setting. Thank you.
Thank you, Councillor Ash. Ms Scott for the applicant.
Thank you, members. The proposed boundary treatment to Barty House has been revised with specialist heritage consultants. A revised landscaped boundary treatment has been designed. The existing wall, which has been subject of partial rebuilding and repair over the years, is still proposed to be resited and rebuilt and will use as many of the original bricks as possible in its rebuilding. The rebuild will also use matching mortar and pointing and will result in bricks that are inappropriate, for example, current non-matching bricks, as have been used in past repairs, removed. The proposed rebuilt wall will be positioned closer to the front wall of Barty House, and fronting Roundwell will be reduced to 600mm to meet the requirements of the wider access and vision displays required to enable the access to the associated housing scheme, to which these works are intrinsically tied and to which you have just granted a resolution to grant subject to the Section 106. It is agreed with your officers the proposals will cause only less than substantial harm to the setting of the listed building. The National Planning Policy Framework requires that where a development proposal will lead to less than substantial harm, this harm should be weighed against the public benefits of the proposal. The works are required in association with the provision of 100 dwellings on land at Barty Farm, a site put forward by the Council for allocation for housing development and is moving fast through the recent examination into the local plan. The Inspector has not raised issue with the site in his interim report, and whilst he has chosen to remove other sites, this site remains. This site forms an important part of the Council's 5-year and 20-year housing supply, and it is put that it provides significant public benefits through the provision of 100 new dwelling units. Of this, 30% will be affordable housing provision. This, together with other contributions and the significant weight that is now afforded to the allocation through the progression of the local plan examination, have added further weight to support the grant of this listed building application. Thank you.
Thank you, Ms Scott. Councillor Cumming?
Thank you, Chairman. And I'm referring to the officer's report in the agenda, which was specifically for this item, 14. On pages 90 and 91, paragraph 7.1 states that the wall is considered curtilage listed. No application was made for non-listed status to separate it from the listing of the building. If rebuilding of the wall were needed, it could be repaired in situ, not moved 2.5 to 3.5 metres nearer to the house, removing a substantial strip of lawn alongside the house, which would impact its current beautiful historic setting. Page 94, paragraph 8.3, acknowledges that this application would be recommended for refusal if not linked to the housing application, which implies that the officer would have advocated refusal on the basis of harm. No application for improved access was made when the capacity of Barty House was substantially increased a few years ago. The harms massively outweigh the benefit. The report also refers on page 93, paragraph 711, to an enhanced public bus service. We've already referred earlier to this is under review for reduction. And again, on access and site visibility sprays, the larger sign, which is shown in photographs 3 and 5 relating to item 14 on the agenda, show a much smaller sign than what is currently there. Thank you very much.
Thank you, Councillor Cumming. Just to remind members that there are urgent updates, that I'm sure you've read them. The first council member, Councillor English, I think you were first on this.
Yeah, as Councillor Spooner said, this is a listed building consent where the balance of factors are different to a planning application. That's both in terms of those things outside of the listed building consent that are in favour of the listed building works being done and those against. So we shouldn't really be bringing quite the same level of discussion of the weight of benefit in planning terms to a listed building consent, that it is relevant, but the balance is somewhat different. I obviously don't have a problem with the reciting as such, because that was reconsidered at... No, it's quite musical, because that was considered. But I'm very concerned that we actually have a wall that bears some resemblance to the wall that was actually there. And we don't have a completely new and different wall, attractive though it may be, which rather removes the point of listing the damn thing in the first place, because you rather expect that when you list something that it bears some resemblance to the actual thing that was being listed in the first place. Otherwise it is a bit pointless to list something. Now, that's not to say that can't be achieved, but I am struggling with despite the other benefits, and as I say, that this is a listed building consent, with the steps, frankly. I don't... Desirable they may or may not be, but they are a major departure from the wall as listed, considerably different. So in effect, it makes it a different wall, a different scheme, and we have moved away from what was listed. Secondly, I want to be absolutely certain that the reduction in height is absolutely only what is required to get the visibility spray, and we are not just overdoing that. So I'm not saying we should turn this down, but I want to actually explore how much we can do to modify this, because I'm not 100% happy with the concept of basically actually replacing the wall with another wall, basically, rather than actually moving it, which is essentially what we've done.
Just so I can set the context, excuse me, you may get bored of my voice, but just to take you through the primary legislation parts, I'm going to take you through effectively paragraph 16 and 66, because in effect what they say is paragraph 16, which relates to listed building work, says, as my colleague has already said, in considering whether to grant listed building consent for any works, the local authority or the Secretary of State shall have special regard to the desirability of preserving the building or its setting or any features of special architectural historic interest which it possesses. That is the same test that is applied to section 66. So just for clarity's sake, I want to then go on to section 17, which again is to power to impose conditions, which I think Councillor English is referring to. Now, in effect, I'm not going to read it verbatim, but it says the reconstruction of a building or any part of it following the execution of any works with the use of original material so far as is practical, and with such alterations, it goes on to the interior of the buildings, but then effectively what it goes to is it says you can impose the conditions to seek to ensure that you use those original materials so you can get as close as possible to that wall. So I think that's where the power the primary legislation sets, and it specifically sets it up in section 17, acknowledging on the basis that if you are going to do harm, which the case officer says it does cause harm, but less than substantial, there is that power which the application seeks to achieve by the imposition of its conditions, by the imposition of, and set out in the urgent updates, the sample panel on site, the reuse of existing materials, the detail of the bond mortar mix and the pointing detail to get as close as possible to that detail. So I think there is that issue, and I'll be quiet soon, because I think what also is the consideration is members also have to consider what you considered on the outline application, on the previous application, where you also considered the setting and the relocation of that wall. So those are all matters that need to be sort of considered when members are making that sort of overall decision on this assessment.
Yeah, go on.
Mr. Chairman, it may just be me, but I think that what Mr. Bailey says is fine. I agree with it. I'm familiar with that. I just think this is actually a radically different departure, and I want to be certain in my... obviously, there is a visibility issue, and that has to be taken on board. But design-wise, this is a radically different design, and I'm not 100%... I remain to be convinced that it's the right design solution. So I'm not really happy to just wave it through.
If I could just address the question that you asked regarding the height of the wall. Where the wall is proposed to be reduced in height to 1 metre, where it runs here parallel along to the access track, this is actually, if you like, a design proposal. It's set out in the heritage statement, and it's all about opening up the views to that elevation and just sort of helping enhance the setting. And that's where the historic advisor has suggested, and also with the introduction to the steps, where the wall is to be reduced by literally a course, that is the absolute, that's all that is required to ensure it meets the visibility displays at the front of the site. Thank you.
Probably is me, probably my aesthetic sense is lacking, but I'm struggling with actually seeing, I'm struggling with actually accepting that. I think we should be trying to preserve something nearer to what was originally there.
Okay. Councillor Prendergast, thank you.
I'm concerned again about the setting and the relocation of the wall. The Conservation Officer is clear that the setting of Barty Farmhouse will be considerably affected, and sort of patching up using correct materials and stuff, that can be done anyway. It doesn't need all these other changes like steps and everything else to completely change the wall. We can do repairs can be done to it if people are, or the owner is minded to. And in my view, there is absolute harm there to the setting of the building, and harm plus no harm doesn't equal zero harm. There's still harm there. So on the basis of that, I just want to cut to the chase and move to refuse this application on the same grounds that we did previously, because the harm is there to the listed building. So the proposed development would cause harm to the setting of the Grade 2 listed Barty Nursing Home and to the fabric of the curtilage wall. And it is considered that the benefits of the development are not sufficient to overcome the harm identified. Thank you.
Do you have a seconder for that before I go around? I know there are other speakers that want to speak. Councillor Powell. A seconder. Okay, so we do have it. Okay. But before I do, I want to give other people a chance to speak. Yeah. Councillor Harwood, please.
Thank you, Chairman. I've spent an awful lot of time comparing the old plans with the new plans and wandering about in front of the site and looking at it. I think where the rot really started with Barty House was when this committee, and I can remember the committee meeting, granted permission for the extension for just like a kind of conservatory on steroids on the southeast edge. The saving grace of that very utilitarian and very significant extension, which is just behind the building so you can't see it here, which has profoundly more impact in short views, long views than the changes to the wall. I think we need to kind of understand that this building has been fairly fundamentally changed fairly recently by a decision by this committee, so, and it's quite important. But I come back to this point around balance. The design of this house is about the equality, about the windows, the blockhouse approach. It is all in the measurements. What we now have, because of the landscaping scheme that went with the extension, is on the southeastern side of the house, we actually have a lot of vegetation and trees and so on, whereas what we've seen on this northwestern edge is a gradual loss through attrition of the vegetation and the landscaping, which is unbalancing the building. Actually, I think that if we move the higher wall, as was proposed in the last listed building application that we actually refused, I think that would accentuate this destabilising the balance, because you've got the high wall, it's moving closer to the building, and you lose those distances, and that setting is compromised. I actually think that the new proposal with the lower wall, and I know it's not part of the listed building consent, but with more landscaping, equalising the east and west of the building, and north and south of the building, I think it works much better. And all our listed buildings evolve in terms of their setting, in terms of their curtilage. And this is a curtilage listing. It's Barty House that's listed. It's the curtilage. I actually think that through having a stepped approach and opening up a new view, which is effectively what you've got, because you'll look onto that northwestern flank, I actually think, I'm not happy about losing all of as much of the lawn as we are. However, if we're balancing the loss of a little bit of essentially very manicured lawn to the biggest delivery of affordable housing in Bearsted since Cross Keys was built, which is what 30 units will be, I know what side I'm coming down on. So I think in terms of design, I am happy with this. I wasn't happy with the last one, the last application that was refused. And I actually think that the benefits for the village, particularly in terms of the affordable housing, do outweigh the harm from the loss of that slither of lawn. I therefore, would like to move, and if it's already, I don't know if there was a seconder for moving, but if so, I'll move an amendment that we grant permission for listed building consent as per the papers, because I think this is a big step forward on the last application.
Yes, Chairman, I was seconding that. I will have a little chat, if you like. I'll keep it short. I think that one of the fears that Councillor English had was about the reconstruction. There are some specialist companies that actually do this work, and there is a wall which has just been completed along by Boxley Church, of which have used specialist companies to do this. But likewise, a shortage of materials. There are a lot of second-hand material companies, businesses around. I've used them in the past, so literally it is possible. I think what we need to do here is to take the photographs of the wall, the good bits of the wall, because some of it has been changed and just made good. So this is an ideal opportunity to actually make the wall the best as we possibly can, and ensure that when we move the wall, because undoubtedly when you take this wall down, you most likely find it's got no foundations anyway. It gives you the opportunity to put foundations in, construct it, so it's got to be there for many, many years. Like Councillor Harwood mentioned, I think this lowering of the wall actually adds to the character. That the main player is the house. A large wall there, I think, doesn't add to the situation at all. So lowering the wall, stepping it down, it will open the view, make sure that photographs are taken of the wall prior to it being removed. But likewise, this is an opportunity for the local councillors to get involved to ensure that the work is done correctly and have an input into it. Thank you.
I just think a couple of issues have come out of that discussion that Councillor Green made that probably need airing at this particular time. The conditions don't obviously take account of an historic survey, photographic survey, to be completed prior to the demolition. So obviously it goes to the proposer as to whether that there would need to be an amendment to the condition, which I would request, if that is agreed, is delegated for the exact wording to the Head of Planning to frame a condition on the basis of a photographic survey shall be taken and submitted to the LPA prior to demolition. I think that's a reasonable condition. It meets the tests. I have no issue with that. So, you know, with deliberations, I think that's something that could be taken forward. With regard to the issues of the monitoring issues, that's obviously a debate that would need to carry on going forward in terms of setting up one of those monitoring committees and as a separate motion. But I'll leave members to decide on that basis. I just thought it's important to address those points that Councillor Greaves made.
Councillor Cox, you've been very... Or was it Councillor Clark? I wasn't quite sure which one. Oh, right. Sorry. You're just...
Thank you, Mr. Chairman. I must confess that I initially thought that Councillor Harwood was going down the I don't want this to change. I think it's absolutely integral that we keep this where it is because it was part of the building. However, I do think that it's all very well to take photographs of what's going to be there, but if we're changing something that is listed, I know it's a curtilage listing, I understand that, but where we say something is listed, it was always my thoughts that we were therefore trying to keep it as it was so people could see what was there before. I mean, I've had experience of the Stone Court Hotel where there's an internal window that has 50 or 60 panes of glass, 7 of which are clear and the rest are frosted. That's listed because when it was being renovated, we thought we'd change them all back to frosting. No, you can't do that because it's listed. So my question here is, it's lovely to keep photographs of what a 1.9 metre wall looks like, but when you're going to turn it into a 0.6 of a metre wall, I really don't see an awful lot of reason to do that, as long as you're going to be using the materials, and we have heard that they'll be using the same materials. They seem to be finding that it's absolutely fine to put an ornamental staircase in to get mildly disabled or disabilitied people to come down that towards a thoroughfare, but so be it. I just really wanted to say I'm learning more and more about what listing really means. And I think the more that the public understand what we have to look at or try to understand ourselves, you'll see how difficult it is to try and defend everything that's out there. And there are cases where we must look practically about what's put before us and then come up what is the best of what we can get for the residents and try and keep what we can for the residents to look at in the future. Thank you.
Councillor Clark.
Chairman, I'm somewhat uneasy about the steps, to be honest. I do feel that this is a curtilage listing. It should link with the history of the building. When it comes to the design, you know, we could almost come up with some concrete acorns either side and say that would have been how they did it back then, or lions maybe. So I am uneasy about it. The fact that we're using the materials, the fact that we're making the access better, the fact that we're making the building look more presentable from a certain angle are all beneficial. But I just find these steps such folly. And I would have much preferred this to be deferred, and perhaps the planning officers have a word with the developer to see whether they really do want these steps. They're not going to be DDA compliant. There's not going to be a ramp there. I just find it a little bit of a Disney aspect when it's completely unnecessary. So if I'm able to, I'd like to recommend that we defer this and have officers talk to the applicant about this, whether we really need these steps or not.
Sorry, perhaps I'm missing something here. At the outline application, permission has been granted for the wall and the staircase. No, hold on a sec. So the setting from the outline application going back. Now, what we are considering here is not the planning application, which takes in the same points. We're looking at the works. So the wall moving, not necessarily, it's a slightly different setting issue, if I can put it that way, as opposed to looking at it. We're looking at a wall where we've already agreed to reduce the height to put in a staircase as part of the outline.
If you take the conservation aspect out, in planning terms, I don't see there any issue with stairs or a particular type of wall or treatment around the boundary, but we're not considering we've already went through the planning review. Now we're looking at something which is to do with protection of something that's already there, the conservation. And I know it's at odds, but it's always been at odds. It was at odds last time when we approved one application and not the other. And I'm uneasy about the fact that we're introducing a complete folly for no real apparent reason.
On this very point, Mr. Chairman, if you permit me.
It's been waiting a long time.
Right, thank you, Mr. Chair. Obviously, I'm seconding kind of the refusal of this application, but there was something that was mentioned earlier on, which was we've got to take this as an individual application, and I think if we took it as an individual application, I don't think we would be granting permission. What we've got to be, I mean, firstly, kind of Barty Farm has got a massive, great big housing estate, basically, kind of put in its place, which is destroying, in my point of view, I mean, that decision's made now. I didn't sit on this committee last year. That was done. I'm having to accept it because it was a democratic process. But what I'm all about is protecting heritage assets. We're in danger of losing a heritage asset. We're in danger of changing the setting of a Grade 2 listed building. Let's be totally honest, the wall's only going to be kind of removed the way it is to add greater access to the building site. And I think the rest of it's been said. In fact, what Councillor Cox said earlier on I thought was absolutely excellent. He actually kind of detailed all the points, exactly what was made, and he gave us the perfect reason why that we should actually get behind this refusal. Thank you.
Thank you. Councillor, I'm just going to give the floor to Councillor Borden.
It was on this particular point.
OK, then. I'll give it to you now. Go on, then.
You will recall, Mr. Chairman, and Mr. Bailey will recall, I specifically asked at length at the pre-meeting whether a different decision could be reached on the planning application and the listed building application, because the legal has just raised that. And the advice you gave me, Mr. Bailey, was it was not good practice, quite the reverse, but that legally it could be done. So I do think the members of the committee need to be aware of that fact. Now, originally I was going to move towards deferral or looking for a delegation to tweak this. I'm not happy about the steps in particular. I'm less unhappy about the rest of it. But I have to say that if the choice is between approving it or not, I'd rather have it approved. But I would like to know whether there's a way of looking at delegated powers in relation to what Councillor Greer said about ward members having a view on this, on any of the design issues, or whether it has to be a deferral if we wanted to look at one or two elements of the design.
Would the committee just give us a couple of minutes just to consider that issue? I just need to take a bit of time and slow the process down just so I can consider in terms of what those implications are, because members have a decision in front of them. I would need to see whether we could actually do that and what the implications are on the previous decision. So if members could give me just a couple of minutes to discuss with the legal officer.
In that case, Mr. Chairman, is it possible just for the committee members to have a 2-minute break to go to the loo? Or
Actually, you take the words out of my mouth. What I would suggest is maybe we have a break and then give them a chance to come back with a... Yeah? So we'll take our 10-minute break now, yeah? Yeah.